Um, the next kind of line of questioning that I'd like to get into is, and say as much as you're comfortable saying with this too, because some of you may not want to talk about everything this, has to do with your strategy currently, right? But at least in broad terms, I think most of you are fairly comfortable because we've discussed this prior to this, talking about how you're using your IP today, or what your plans are in the future for what you're kind of currently holding now, and is this directly in line with your business or your product, or have those things kind of drifted apart and you've got two different things going on where your IP has nothing to do with what your product anymore, but it still has a lot of value. Sometimes that happens, or sometimes they kind of they really line up, and everything in scenarios in between as well. So, and feel free to talk about how you're extracting, or you have extracted, or you plan to extract value out of your IP portfolios also. So, I'll open that up to any of you guys who want to jump in. Tom,
I'm happy to start. So for us, I guess I would say you've heard some of the sort of proactive, or I don't know that they're offensive, right? We're not out there pursuing. Yeah, it's mainly defensive, right? So if we design an aircraft, we want to make sure that people don't copy that aircraft. If we have a particular manufacturing process, there's a lot of things that we plan to deploy. 3D printing, for example, we were talking about today, is something we're using already on our prototypes. Basically anything that we have a hard time getting a part for, we just throw on a 3D printer and whiz bang, there you go. And we kind of step back and say, I wonder if there's any IP in this, right? I can remember working at Tesla where it would be like we'd be beholden to a supplier on a prototype because the automotive suppliers, most of them were playing ball, but some of them weren't. And the delays on the Tesla, the history of Tesla have been pretty well documented, and a lot of that was due to supply chain. So that kind of leads us into manufacturing processes. But for example, the name of the game in eVTOL, obviously everybody's going towards this idea of autonomous flight, right? So that's all algorithm-based software, and so we're very much, that's really the bleeding edge for us. Is what does it mean to be making autonomous flight algorithms, and what, if any of that, is patentable, needs to be protected. So that's really the area of focus for us right now.
Right, and you have kind of, I know because I'm involved with this, but you guys have several different kind of silos of different IP that you have, and because of this fancy contract negotiations that you're involved in, that's siloed IP in different ways as well.
Yeah, hybrid energy storage is another area, right? Because there's so many different pieces, and again, it's emerging technology, and it's also in a space that, as I mentioned before, has not been innovating. So, and I think it brings up another point too, right? Which is going into a space where you have the giants, Airbus, Boeing, Embraer, they're basically owning the space right now. There's the defensive strategy in some industries. The larger, more entrenched companies have used an offensive IP strategy where they don't even know if their patent is applicable, but they're just going to outspend you until they will spend a startup to death. Essentially, is one IP strategy. And so we have to, back to the point of like how much should you spend. For us, we're looking at that from the perspective of how much can you afford not to spend. If that's a potential future where one of the bigger companies comes after you for something. So it's a pretty important piece for us.
Sure, and just I know that I think that you want to say a little bit something about this also, that you are also involved with someone who is publicly um, boisterous or publicly well known. They've created a movie having to do with patent trolls. And do you want to say what?
Well, I mentioned this.
How that's changed the perspective of the company.
Yeah, I mentioned this before. So our philosophy on that is that we really just want to look for protection, look to get patents on things that we're doing as opposed to things that we're not doing. So this person who founded X-Plane and Xavion, these flight simulation and essentially an app, he was sued by a patent troll. So what does that mean, right? So it's a often misused term, but essentially what it means is that he had an app, a very neat app, which if you're a private pilot and you get yourself into trouble, this app will essentially show you goalposts and basically say, just fly between these goalposts and this is going to take you to your nearest safe landing. So this is an amazing app, and it's saved people's lives because private pilots often get disoriented. If you remember John F. Kennedy Jr., that was exactly what happened. Pilot disorientation, and this is a way to get home safely. And so this gentleman who had this was sued by someone who owned a patent for an Android device that has to, Unilock is the name of the company. They had a patent for an Android device that needs to check to a centralized server to authenticate a license. That was the patent. Seems pretty general, huh? He did not like this, so he, rather than buckle, he took on this person and made a movie about it because he's an entrepreneur with a whole lot of gusto.
Yeah.
And it's great. It's an amazing thing that he did, and so we brought him into the business as a principal in our business, and he brings with him that IP, and so it was very interesting to bring him and his passion and his 25 years of ingenuity in essentially what is now virtual reality, to bring that into our business, but to need to do that in a way that made him comfortable with, I'm not going to agree to any boilerplate, sort of like this is what we'll go to arbitration in the case of a patent suit. We had to be very specific and principled about how we did that because this was a person who was like, no, this is unjust. And essentially it was like people should not be, filing against these types of, specious patents, essentially. So we're really coming at it from both. We see a very useful, professional, and above board use for all of this stuff, but we also need to negotiate the fact that there are people out there that abuse the system. So. It's pretty interesting.
Yeah, thanks, Tom. Jay, you, as you mentioned earlier, you still have a lot of IP, even though you were recently acquired. And you're also the co-founder of another new company. What are those companies doing today with IP, and kind of what is what sort of strategy do you guys have in mind with those? Do you want to weigh in on any of that? Broadly, even.
So with the IP that doesn't relate to paperless parts, it's in process, so I'm looking to figure out how to monetize it and to take as many patent applications into patents, and perhaps I'll build a business around it, perhaps I'll sell it, perhaps I'll license it, I don't know. What Keegan has helped me do with the CAD Siri, once we get the basic patent, then maybe I'll just touch on some nuts and bolts that to me have been fun in learning in the patent process and relates to the strategy. But now that we have the core patent for CAD Siri, we're doing a lot of continuations, if I have the... So we're making this one patent a lot stronger and fleshing it out. So that's one strategy. Do you file different patents, or do you go for that core patent perhaps and makes it stronger? One of the things that we did, which I think was really valuable, is we did not publish any of our patents along the way. And again, that's a strategy. We filed provisionals to gain time to decide if we actually wanted to pursue the patent, invest the time and the money to create a non-provisional application. So for me, that was a quick way to get that date stamp. As we've gone along, I've learned also that there's different you can get your patent application to different places in the patent office where the information is on record, even if you abandon it or withdraw it. For some of the stuff that we did not want to make the recipe public knowledge, but in case anyone else ever came up with the same idea or learned what we did and filed a patent, we had a defense. We had that prior art existing in the patent office, but it was non-published and not identifiable to anyone out there. We also had a patent application where, I forget the correct term, but essentially we were told we would get the patent, but in the time in between, I was just uncomfortable with some of the verbiage in the disclosure, what's the body of the application?
Sure, yeah,
So-
the specification. Yeah.
So without losing the priority date, Keegan helped me so that we could essentially black out, retract the stuff that I didn't want visible, and then refile with the patent office so that we would be granted the patent on the same content. But over time, you learn things.
Yeah,
So-
I think that I'm glad you brought all this up. I had actually not thought about that kind of
There's
whole
all
thing in a
sorts
while,
of
but
fun things that you can do.
yeah, your strategy has been a lot of fun along the way. And part of Jay's strategy was we want to go after some IP because we know we're doing some things that we need to protect, but we don't want anyone to ever find out about it. and so how are we going to do that, right? And so part of this strategy, what he's trying to describe here is that we dragged out patent prosecution
Yeah.
as long as we possibly could in most cases. And
We can make a decision at the last minute whether we actually wanted to make it public or not.
right,
On the flip side, what was the within the year review? What's that called? We filed a patent
doing
application.
a track one accelerated.
We did a
program
track one
applications, yeah.
because we wanted to get a patent very quickly so that, and this happened before the acquirer approached us, but we were positioning ourselves and we didn't want to wait 5 years to get a patent. So we did a track one so that we would have a patent on hand when an acquirer came along. So there's a lot of strategy in your patent agent, and your attorneys can help you walk through that.
Right. Yeah. I mean, that was a great. It was interesting to drag things out as long as possible and not to want to show. I think most people go into this thinking we're going to take as much IP to the table, especially when you're thinking about being acquired or going into an IPO or M&A or whatever it is, that you want to have as much IP on the table as you can, right? And that you'll maybe extract some more value if you actually have patents in hand. And in this case, the strategy was actually different, that we didn't want to have hardly any patents in hand at all. That we wanted whoever was to acquire the company to be able to make those decisions on their own, because some of it was so important that we didn't want to reveal the whole secret sauce to other players in the industry, right? So that you can't once you ring the bell, you can't unring it, right? So once someone sees this stuff, you can't kind of take it away. Now they're going to be thinking about how to develop other innovations based upon what they've seen. If those applications are in the public domain.